All rise. Oyez, oyez, oyez. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning. We want to welcome you to the Tennessee Court of Appeals. This morning, your panel consists of Judge Fryson to my right, Judge Davis to my left, and myself, Judge McClarty. I assume that the parties are familiar with our procedure, where we have the appellant first, and then the appellee, and then the appellant come back with rebuttal. I'm sure you're aware of the timings. We have not received any requests for any additional time, so the normal timing will remain in effect. That's 15 minutes per side. Okay. Are there any preliminary matters this morning before we start our docket?
No, Your Honor.
Okay. In that case, Mr. Clerk, will you please call the first case?
Yes, sir. Nyrstar, Tennessee Mines, Strawberry Plains, LLC v. Mossy Creek Mining, LLC.
And the appellant, you can reserve your time for rebuttal if you so desire. Mm-hmm.
Your Honor, yes, we'd like to reserve 5 minutes for rebuttal, please.
You can. Mm-hmm.
May I proceed?
You may proceed.
Thank you, Your Honor. May it please the court, my name is Bill Katz, along with Ed Scheip and Dan Zaleski from Nyrstar. I represent the petitioner, Nyrstar Tennessee Mines, Strawberry Plains, which I will refer to today as Strawberry Plains. This appeal concerns the improper denial of Strawberry Plains' motion to compel arbitration. We are asking this court to reverse and remand with instructions to grant that motion to compel arbitration, and have presented two issues on appeal that I'm going to discuss in detail in a minute. The first issue is the issue that I'll refer to as the who decides issue. Should the issue of arbitrability be decided by a court or the arbitrator? As we've articulated on our brief, it should be decided by the arbitrator, and the trial court erred in deciding otherwise. The second issue has to do with, even if a court were the appropriate forum to decide the arbitrability issue, are Mossy Creek's counterclaims, arbitrable, and in fact that they are, and the trial court erred in finding that they were not. So for those reasons, we are asking the court to reverse and remand. So let me talk for just a minute before I talk about the legal issues, just about the factual background and the parties' arbitration agreement. My client owns and operates a zinc mining operation called the Young Mine and Mill in Johnson County, Tennessee. My client and Mossy Creek have entered into a series of contracts referred to as the Young Mine Agreements. Those agreements give Mossy Creek the right to enter onto our property and operate an agricultural lime business. Mossy agricultural lime is a byproduct of our zinc mining operation. Mossy Creek takes that agricultural lime, sells it across state lines to farmers. Those Young Mine agreements contain the arbitration agreement that's at issue in this case. And in fact, the parties have conducted in the past at least 2 different arbitrations subject to that agreement, including an arbitration that started in 2023 and concluded in 2024, and actually resulted in the trial court proceeding from which this appeal arises. We had an arbitration. Our arbitrator, Chancellor Ellen Hobbs Lyle, sat as the arbitrator. She ruled in favor of my client, Strawberry Plains, ordered Mossy Creek to pay my client a certain amount of money, which Mossy Creek did, and the arbitration award was confirmed in the trial court below. Mossy Creek did not contest confirmation. Mossy Creek did not argue that the arbitration agreement had gone away or been superseded by some later agreements, including the settlement agreement that's at issue here. In fact, it's notable that many of the same arguments that Mossy Creek is presenting to this court It also presented in the arbitration, initially arguing that Chancellor Lyle did not have the power to rule on the claims in that arbitration. She issued a detailed reasoned award. It's order number 2. It's in the record. And I apologize, I don't have the volume number, but I can find that for you. But it's located in one of the volumes at record page 100 through 110. So she issued a 10-page decision that considered many of these same arguments that Mossy Creek is making now, and she rejected them. And she found that the arbitrator, she as the arbitrator, had the right to decide arbitrability, and also that the claims that were being brought in that arbitration were in fact arbitrable. And we believe, Your Honor, that you all should follow similar reasoning and reach the same conclusion. Basically that Nyrstar's motion to compel arbitration should have been granted, and that the counterclaims asserted by Mossy Creek are in fact arbitrable. So let me turn, if I may, to the first issue. This is the issue of who decides. And here, under the parties' arbitration agreement, the issue of arbitrability should be decided by an arbitrator, not a court. How do we know that? Well, 2 main reasons. When you look at the arbitration agreement, which is contained in the Young Mine Agreements, it's drafted extremely broadly. And it says that it applies to any dispute arising out of or relating to the Young Mine Agreements must be resolved through binding arbitration. And that relating to language is very important, and the any dispute language is very important. So at the outset, we clearly have a dispute about arbitrability, about who decides. Should it be a court? Should it be an arbitrator? That is a dispute that is within the language of the any dispute provisions of the arbitration agreement. The question then is also that in that situation, this dispute relates to the Young Mine Agreements. How do we know that? Well, Mossy Creek would tell you that there are counterclaims that are at issue here, those that rise under this separate settlement agreement. Well, actually, no, they may arise under that separate settlement agreement, but they clearly relate to the arbitration agreement. How do we know that? Mossy Creek's counterclaims here are seeking to claw back money that Chancellor Lyle ordered Mossy Creek to pay my client in that arbitration. So in other words, but for that arbitration, if that arbitration had never existed, if Chancellor Lyle had never ruled in my client's favor, if she had never ordered Mossy Creek to pay my client, there would be no indemnity counterclaims. This case would not exist. This appeal would not exist. We would have never met. So the reason that the counterclaims here clearly relate to the Young Mine Agreements are they are trying to claw back money that were issued in an arbitration pursuant to that arbitration agreement. Now,
let me ask you this, though. In terms of what they're seeking in the counterclaim, where in the, not the settlement agreement that contains the indemnification, let's say, where is the basis for their counterclaims found, if not in the settlement agreement?
well, Your Honor, the counterclaim, here's the way I would think about it, Your Honor. There's 2 issues. There's the question of arising under, which I think is your question of what are they based on. And then there's a second question of what do they relate to. And so what matters here is if you think of it like a Venn diagram, right? You have these 2 circles, okay? And the issue is there's overlap in the middle where the counterclaims, although they arise under the settlement agreement because they're based upon paragraph 3 of the settlement agreement.
The settlement agreement relates to the original documents.
Correct. In fact, and so although they arise under the settlement agreement, they still relate to the Young Mine Agreements and the original easement. How do we know that? Well, for a couple reasons. One, because Tennessee courts, including we cite the Lacey versus Vanderbilt case and Black's Law Dictionary, say that relating to is incredibly broad, right? It's a low bar to meet relating to. It just has to be connected in some way. How do we know they're connected? Well, as I just said, if it weren't for the arbitration award under the original easement, under the arbitration agreement, they wouldn't have filed these counterclaims. But more importantly, and I would encourage the court to take a look at this, the settlement agreement is actually part of the Young Mine Agreements. Well, how do we know that? Look at Exhibit B to the settlement agreement. Exhibit B to the settlement agreement includes an agreement that is part of the Young Mine Agreements. It's called the amending agreement, okay? And this is actually an agreement that Chancellor Lyle, they made these same arguments based upon Exhibit B to the settlement agreement in front of Chancellor Lyle, and she said, wait a minute, guys, look at Exhibit B. It says in paragraph 3, attached to Exhibit B, attached to the settlement agreement, it says we're going to amend a couple of easements under the Young Mine agreements. So Mossy Creek doesn't have the right to go on the tailings storage facility or access the tailings dam. Fine. But what it also says in Section 3 of Exhibit B to the settlement agreement is all other terms and conditions in the Young Mine agreements remain in full force and effect. And when Chancellor Lyle looked at that language, she said that means that everything else, including the arbitration agreement, remains in full force and effect. And this court should do likewise. So I think the answer to your question, Your Honor, just to sum up, is relating to is incredibly broad, and even if the claims arise under the settlement agreement, they can still relate to the Young Mine agreements. And when you look at the settlement agreement itself is part of the Young Mine agreements because that settlement agreement was designed to do several things, including amending in a very limited part certain provisions and easements in the Young Mine agreements, but it also expressly reaffirmed that all the other terms and conditions of the Young Mine agreements, which would encompass the arbitration agreement, remain in full force and effect. And that's exactly what Chancellor Lyle said, and that's what we would ask the court to do here. So I think it's clear that the arbitrator should have decided. If you agree with us on the first issue, you don't have to reach the second issue, okay? So if you agree with us that this issue of arbitrability should have been decided by an arbitrator, you can reverse, remand with instructions to grant the motion, and you don't have to get to the second issue. However, just real briefly in the amount of time I have left, if you do reach the second issue for some reason, the counterclaims, as I said, should be arbitrated, okay? How do we know that? Again, the language relating to is incredibly broad. As I've just explained, the counterclaims, even if they arise under the settlement agreement, they relate to the Young Mine agreements. For all the reasons that Chancellor Lyle also found that the claims were arbitrable, the court should do likewise. Thank you.
You have your rebuttal time. Yes, sir.
May it please the court, my name is Kyle Carpenter. Along with Caitlin Tweel, I represent Mossy Creek Mining. We would not be here but for the settlement agreement because there is no place else that gives us the right to indemnity. And we had no right to indemnity until after the arbitration proceeding that was conducted by Judge Lyle. The background is important because my client, Mossy Creek, the Young Mine was closed, and there's what's called the tailings dam, or the tailings storage facility up there. Huge amount of lime product. And my client bought that and was going to market the lime from that tailings dam. That was fine as long as the mine was closed. But then an outfit called Glencore came in, reopened the mine, started mining, and when they did, they put their stuff, the byproducts, on the tailings dam. Nyrstar took over from Glencore, did the same thing. Well, when they did that, it contaminated what was already in the tailings dam. And so it made what had been a very valuable asset, it turned it into a liability in my client's judgment. So we got into litigation, we got into arbitration, and then in 2012, so 10 years after the original Young Mine agreements, Mossy Creek transferred ownership of the tailings dam to Nyrstar, to Strawberry Plains. And that's important because the original, what we've called the Young Mine agreements, there's more than one agreement, but there were 5 easements. There were easements to store equipment, easement for signage, easement for a scale house, an easement to go up and take things off the tailings dam. That was done away with when they transferred the ownership to Nyrstar. And it was important because of the liability. It was important to get indemnity. So that indemnity is set forth in paragraph 3 of the settlement agreement. And then in paragraph 9 is where we have the procedure to be followed to enforce the indemnity. The parties agree that this agreement is made in Tennessee. Tennessee law shall govern. Should a dispute between the parties, between or among the parties concerning this agreement, including but not limited to a dispute involving the interpretation, application, or compliance with any term or condition of this agreement, the parties hereby consent to the jurisdiction of the state and federal courts in Tennessee. That was a clear intention that if we were going to seek indemnity, we had to do it in the courts. And if what Nyrstar, Strawberry Plains, wants to have this court do, that is going to do away with the provisions that we bargained for in 2012. It will make them null.
Does that paragraph say you have to do it in the courts, or does it say if you're going to do it in the courts, you can, not that it has to be in Tennessee, but that you agree that it can be in Tennessee?
Well, that's a good question, and I think a fair reading says it has to be in courts, because it, in addition to what I've read, it says in the event the party brings suit. So you don't bring a suit in an arbitration, you bring a claim. So I think when the parties talk about suit and talk about prevailing parties in said suit, clearly in the common usage of the language, they're saying that the jurisdiction and venue for any dispute should be in the courts and not in arbitration.
What about his argument that the settlement agreement incorporates the terms of the original agreement, which includes the arbitration?
Well, I really don't believe that to be the case. If you look at paragraph 3, it says that as consideration, the parties agreed as follows: to amend the Young Mine Agreement as set forth in Exhibit B so that the ownership interests are transferred. So it is incorporated to that extent. And then it says to amend and revoke the easements in the Young Mine Agreement as set forth in Exhibit B. So I think the import of attaching Exhibit B and incorporating Exhibit B was to accomplish those things: transfer ownership, do away with one of the 5 easements, the easement that allowed Mossy Creek to go on the tailings dam and remove tailings. That's my reading of it. It is black letter law that the court's obligation is to construe a contract according to its plain language and to try to give effect to all provisions, and to try and what they want you to do would in effect strike the indemnity provision, strike our right to go to court under the indemnity provision. It should, our view is this should be construed as written, and that we should have the right, as Judge Stevens found, to pursue our indemnity claim in court. they want to rely on the related to, and if their definition of related to is follows, then this provision, we would never go to court. Everything, under their view, is going to be related to. Does the court have any other questions?
I hear none. Thank you very much. Yes, sir, your rebuttal.
So, thank you, Your Honor. Just real briefly, Your Honor, in response to your question, I think if you look at paragraph 9, it's not mandatory. It talks about, if you read it, it just says that should a dispute arise, that the parties consent to jurisdiction over their persons by the state and federal courts of Tennessee. So again, it's not even a venue provision, it's a consent to jurisdiction provision. We cite in our briefs cases like the Iron Horse case, the Scepter case, the Flight Solutions case that make it clear that if the parties, and again, these are sophisticated parties, both Strawberry Plains and Mossy Creek, sophisticated parties that have signed a variety of contracts over the years, if they wanted to make it clear that any dispute that related to indemnity counterclaims or arising out of the settlement agreement had to be filed only in the state or federal courts in Tennessee, they could have done so by using some of the language that's discussed in those Iron Horse, Scepter, and Flight Solutions cases. They would say may only be brought in those venues, or those are the exclusive, forums for a dispute like that. That's not what they say. I think there is no express language in the settlement agreement that eliminates the right to arbitrate or Mossy Creek's obligation to arbitrate. I think when it comes to the provisions that Mr. Carpenter was reading from sections 3A and 3B of the settlement agreement, obviously, again, go look at Exhibit B to the settlement agreement. I think that's where you find the specific and express language I was referring to earlier that reaffirmed the validity of the Young Mine agreements, including the arbitration provision. Again, that's in, and again, I'm looking, this is at page 170 of the record. I'm not sure what the volume is, but paragraph 3 of Exhibit B to the settlement agreement says, except for those easement rights that are expressly or necessarily by implication terminated or modified under this agreement, all terms and conditions in the Young Mine agreements shall remain in full force and effect. Okay, and this is signed by both the parties, and this is part of the settlement agreement. So again, the settlement agreement, and again, the only thing that's being modified were easement rights. Obviously, the arbitration agreement, that's not an easement right. As Mr. Carpenter explained, what was being modified was my client was taking ownership of the tailings dam, and Mossy Creek was no longer going to have an easement to access the tailings dam. That's the only thing that changed. Otherwise, in the language I just read to you, all the other terms and conditions in the Young Mine agreements, including the arbitration provision, stays in full force and effect. And that's similar to what Chancellor Lyle found in our arbitration. So here, I think the other thing I'd want to mention on the first issue of who decides that I neglected to mention at the outset is, in addition to sending to an arbitrator all issues of arbitrability based upon the broad language in the arbitration agreement, any dispute arising out of or relating to, I think the other issue that we mentioned in our briefs that, again, Mossy Creek doesn't really engage with in its briefs is the fact that the arbitration agreement incorporates the AAA rules. And we cite this court to courts that have found, interpreting similar provisions, that incorporation of the AAA rules is in and of itself an indication that the parties agreed to have an arbitrator decide arbitrability. Why is that? Well, if you look at the AAA rules, they have a specific rule that says the arbitrator gets to decide his or her jurisdiction. And for those reasons, that's another basis where in particular the Sixth Circuit interpreting similar arbitration provisions has found that incorporation of the AAA rules is another reason to have an arbitrator decide arbitrability. So in closing, the arbitration agreement here is very broad. It applies to anything relating to the Young Mine agreements. As I've explained earlier, the settlement agreement, including its Exhibit B, relates to, at a minimum, relates to the arbitration agreement, and therefore, given the broad language in the arbitration agreement, given the incorporation of the AAA rules, the issue of arbitrability should have been decided in the first instance by an arbitrator, not by the trial court below. That in and of itself, the court could rule on that issue in our favor, reverse and remand with instructions to have the arbitrator decide arbitrability, and you wouldn't have to reach the second issue. And I think what's important here is we're not talking about the merits of Mossy Creek's counterclaims. Mossy Creek is going to get its proverbial day in court, even if that day in court happens to be in an arbitration, okay? But ultimately, you know, this is just saying like, hey, who should decide? And we think it should be an arbitrator for all the reasons articulated in our briefs. So thank you all very much. Appreciate the court's time.
Thank you. I want to thank both of the parties for your presentation. You've given us something to think about. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. If there's nothing further, then the parties may